Welcome to the second part of this video series by Caliber and Career, where we are looking at the top 20 legal developments of 2020. If you haven't checked out the first part, please do, and here we go in the second part. The first topic is developments in the Juvenile Justice Act 2015. So this year, through a couple of cases, the judiciary has secured the bail rights of these juveniles. Firstly, there was a suo motu case in the Supreme Court regarding exploitation of children in orphanages in the state of Tamil Nadu, where it was held that a juvenile accused under the special legislation is not to be held in jail or police lockup no matter what the circumstance. Also, in the landmark case of Anamul Haq versus Union of India, the Patna High Court said that the Section 12 of the Juvenile Justice Act has clear overriding powers over Section 37 of the NDPS Act, which is the Narcotic Drugs and Psychotropic Substances Act.
Sushila Aggarwal versus NCT of Delhi. So still on the subject of bails, the Supreme Court in this case settled a long prolonged battle of conflicting judicial precedents with respect to the time limits on anticipatory bails. What is an anticipatory bail? An anticipatory bail is issued for a person who is anticipating his arrest. Hence, it is a direction to release a person even before he is arrested. So what did the court say in this case? It held that attaching a time limit to an order of anticipatory bail is not permissible unless special and peculiar circumstances require it to be so provided. In normal circumstances, an anticipatory bail should be free of a time limit and can safely continue till the end of the trial. Farm bills. So if you had been paying attention to news last year, you may remember the three controversial agricultural bills that the farmers were protesting against, noticeably in the regions around Delhi, Haryana and Punjab, but also other states. So why it's in the news now? Because it has received the President's assent to become the controversial Farm Acts. So what was in here? The Act stipulates a farming agreement between the farmer and the buyer before production. Also, a 3-tier dispute management mechanism is stipulated, with the conciliation board, a subdivisional magistrate, and an appellant authority. Moreover, trade outside the yards and mandis has been allowed. So this is one point where the farmers have a problem. They feel that creation of private mandis along with the state-run APMC, which is Agriculture Produce Market Committees, will push all agricultural businesses towards private markets. Like the rich corporates would control the agriculture businesses. Also, the market fee has been abolished. Development in reservations for backward classes. So recently, there have been 2 important cases with respect to reservations for backward classes, where 2 constitution benches of the Apex Court gave directions. Firstly, in the case of Shabrulo Leela Prasad Rao and others versus the state of Andhra Pradesh and others, it was held that 100% reservation for STs or scheduled tribes in teaching positions in schools situated in scheduled areas is invalid and should not happen. Second, in the case of state of Punjab versus Davinder Singh, it was held that a state government has the power to make subclassification within classes of reservation, something which was believed that only governor has the power to make. The Sabarimala Issue. As you may know, the Sabarimala temple in Kerala has been in news for some time now because of its practice of not allowing women from the ages of 10 to 50 into the temple, supposedly because they are in their fertility age and it would be impure for them to enter the temple, which makes little sense. And over the past few years, there have been many attempts by legal activists and social activists to change this practice as it discriminates against women. So regarding this, in the Sabarimala review petition, some questions of law were referred to a larger bench for consideration. This reference was challenged and a ninth judge bench of the apex court held that a reference to a larger bench may be made in a review petition, and thus it suffered from no infirmity, or that such reference holds strong. Arnab Goswami bail proceedings. So probably all of you know Arnab Goswami, an entertainer cum journalist, or I would say more of an entertainer and less of a journalist. So Mr. Goswami was arrested by Maharashtra police and was sent to a 14 days judicial custody in relation with the 2018 amendments of suicide case. So obviously Mr. Goswami filed a bail application which wasn't even considered by the Bombay High Court, not even prima facie. And for this, it suffered criticism by the apex court. The Supreme Court reminded the courts of their sacred duty to protect the liberty of individuals. The Supreme Court also provided interim bail to Arnab Goswami and was of the opinion that the abatement of suicide case was not made out. Permanent Commission to Women Officers in Army. So, in a very welcome judgment, the division bench of the apex court said that permanent commission in Army shall apply to women officers as well, irrespective of their years in service. So this is a great milestone for women's rights, and to understand more about its significance in the Army, I would really suggest you to read the history and evolution of the rights of the women who serve in the Army. Also, the court rejected the government's stand on the physiological limitations as being based on sex stereotypes and gender discrimination against women, and said that blanket refusal of consideration of women for criteria or command appointments is not permissible in law. The Medical Termination of Pregnancy Amendment Bill 2020. So this amendment bill amended the original Act of 1971, and in a very women-friendly approach to the problem, it increased the permissible time before the pregnancy abortion can be carried out from 20 weeks to 24 weeks on consultation with 2 doctors. Moreover, it provides for medical boards to decide abnormal cases where abortion after even 24 weeks may be granted. So this is like putting autonomy of women and their fertility rights before the right to life of the unborn child. Also, this amendment bill insists on the operation being performed by doctors specializing in gynecology and obstetrics. As the last topic of this video, we have Surrogacy Regulation Bill of 2020. Surrogacy is a method of assisted reproduction where intended parents work with a surrogate or a substitute mother who will carry and care for their baby until birth. So why is it in the news? The Surrogacy Regulation Bill of 2019 was referred to a select committee and is now awaiting presidential assent under the current name. Now let us look at some features of the bill. The bill establishes a national surrogacy board at the center and state surrogacy boards in the states, which have mainly advisory and administrative functions. Also, the bill bans commercial surrogacy, which is being a surrogate in exchange for an amount of money, and it also lays down criteria and eligibility for women who may opt for the process. Also, in a very liberal interpretation, it widens the earlier definition to include an intending woman who is not married to opt for surrogacy as well. So that is it for today in this video. If you like our content, do subscribe to our YouTube channel and follow us on our social media handles at Instagram and Facebook. Thank you.